accused person under Articles 49(1)H. Guarantees the right for any person to be released on bail and or bond.
A bond of 1 million shillings with a surety or a cash bill of 500,000.
Matter of that, I continue on record for the first, the third, and sixth accused person. And Mr. Mwendwa for the third. For the first, fourth, and sixth. Yes, Your Honor. I won't brief Mr. Mwendwa for the third. The matter has proceeded in his absence as it was. The matter is a fresh matter. Let's come back to it.
I'm not ready to proceed, Your Honor. You know, the investigative officers informed me. Your Honor, he informed the same. My predecessor was in Court 1. However, Your Honor, the said prosecutor left before the issue was addressed.
48 of the Anti-Corruption and Economic Crimes Act number 3 of 2003, as well as failing to comply with any law, applicable procedures and guidelines relating to the procurement and disposal, contrary to section 45(2)(b), read with section 48 of the Anti-Corruption and Economic Crimes Act number 3 of 2003. In court, Mrs. Onunga for the prosecution stated that the compelling grounds for the application to detain the respondent were that he was the president of FKF in the management and control of public funds advanced by the government of Kenya and other donors to develop football, and that being in that position, he had authority and influence over potential witnesses who are employees of FKF by using his influence or intimidation on the same people. The prosecution went on to state that though the respondent was arrested on the 12th of November 2021, the investigations were not concluded as certain documents were in his custody in his office, which was closed during the weekend. She went on to argue that the respondent had been brought to court within 24 hours as stipulated by the Constitution and prayed to court for 14 days to hold him so that they could conclude the investigation. The respondent's counsel, Mr. Mwendwa, opposed the application on grounds of the state had failed to show compelling reasons to detain the respondent, and to this he argued that there was a report prepared by the registrar or committee appointed by the Cabinet Secretary of Sports in respect to the management and financial position of FKF, and this could not be used as a reason to detain him. The second ground was the test of good faith. Mr. Mwendwa went on to state that even if the reasons could be compelling, the state had failed to demonstrate that the application for detention was brought in good faith. The court ought to deny that prayer. He said that the application for detention was not brought in good faith, and therefore the court ought to deny that said prayer. He stated that during the respondent's arrest, the public was informed that the mismanagement was for Kenya shillings 513 million, yet the affidavit before court gave the figure of 8.5 million and another 29 million alleged to have been withdrawn. Justice Imureithi averred that the recent trend where a person is arrested and arraigned in court within 24 hours, specifically for the prosecution to seek extension of time to continue to detain such a person without a charge or a holding charge being preferred against such a person is unconstitutional. The police have no authority in law to arrest and detain any person without sufficient grounds. Those grounds can only be sufficient if the police have prima facie evidence which can enable such a person be charged with a disclosed offense. By the time the prosecution sought extension to detain the respondent, the grounds of the notice of motion application are sufficient to be on the holding charge for the respondent to be informed of the reason for further detention as per Article 49G of the Constitution of Kenya. Not bringing a holding charge after having detained the respondent for a whole weekend would seem like the prosecution was fishing for evidence. I find that the prosecution ought to have presented a holding charge as they sought extension to retain the respondent. Number 2 was whether there was good faith in the prayer for continued detention of the respondent. In their submissions, the prosecution raised up very valid points on their apprehension that the respondent might tamper with the evidence and the witnesses, thus the application to detain him further. But in the reply of the respondents, the counsel stated that there was no good faith on the part of the state, as they did not bring a holding charge, and also that the public had been informed that the amount in question was 513 million, whilst in the affidavit they only mentioned 8.5 million and 29 million, thus spoiling the respondent's image in the eyes of the public. I find that though it is not clear who gave the said amount of Kenya shillings 513 million to the public, it is clear that having held the respondent over the weekend was sufficient time for the prosecution to present a holding charge before the court. I also find that there was no good faith on the part of the Republic, that is stroke prosecution, in seeking further detention of the respondent without the said holding charge. In conclusion, the grounds stated in the notice of motion application dated 15th of November 2021 are not sufficient to keep the respondent detained, as investigations are still ongoing. In any case, the bond terms given on the same date gave conditions to ensure that the investigations were not interfered with. The prosecution is given 7 days from today to bring a charge against the respondent and or close this miscellaneous file. The bond terms are extended to 25th of November 2021. So that my ruling is not interpreted differently. What I mean is, the conditions that I gave in his bond terms are so that they do not interfere with the investigations. So I hope and expect that the investigations are still ongoing. If they need him to go to the IO, if the IO asks him to attend to them, then he's supposed to attend to them. That's okay.
I think the one terms are very clear.
My name may I add something? Okay, we have held the rule of law, and so we shall comply with what you have said. But I would like to add very respectfully to the prosecution in the country, but not do things in an arbitrary manner at all. They have an opportunity or an option in this matter to call and they can sort out this matter themselves without going to the court. That's my own humble view. I may point out something that they did which I thought I should mention to you. Mwendwa was brought into the court as the photo. He was handcuffed. Your Honor, the law is very clear. You do not handcuff an individual unless you are. It has become a habit of handcuffing people who are in authority in the country. And I'm hoping that the prosecutor will send that message to the Inspector General, to the Director of Criminal Investigation, that we do not handcuff people who are holding social positions in society. You are actually imputing things that should not exist. In the civilized world at the moment, the world is moving from handcuffing senior members of society who are actually peculiar of society. And indeed, our friend here, Mwendwa, is a pillar of the culture in Kenya. That's all.
Just one point I wanted to just bring the knowledge of the court. We have information that FIFA has called for meeting with the minister. And I believe that this is in the interest of sports. The ban, I think, from Tuesday next week. And that has huge implications. The league, the funding to youth clubs, and to sport generally, this country, football. So we hope that between now and the 7 days that we've given, now, when Kenya is banned, it is not Mwendwa who suffers. It is the youth. It is those clubs that benefit from FIFA. It is the international exposure of football in this country. So we are grateful that we're given 7 days, because within that time, that will enable the stakeholders to come together. Even the Senate is here. They will then know that there is need to sort out the game of football in this country, so that we are pleased to do it for the benefit of the youth and those who play.
Thank you. To bring the law into ridicule, magistrates and judges should not be handcuffed.
Don't worry, Your Honor, we are telling the people of Kenya, because this is the essence of what happened, right? When we get an opportunity of this kind, the mass of necessity is dead. Because you see, for the people of Kenya, for those who make these decisions, to understand that that is wrong. It is very wrong. Because even in the basement, he was not in handcuffs. So why bring him in handcuffs?
It's a young football, the whole world. Let us respect him. He's offering hope to the entire Kenya. We need young men like him to get into power. Thank you.
Stopping the IO from doing that. Neither have I stopped the IO from continuing with his investigation. Those investigations should be ongoing as we speak.
Then I'm going to maintain my earlier directions in terms of bail, such that if Mwendwa was able to deposit the 4 million shillings, then he'll stay out for the period of 7 days, within which the state has is at liberty. They can prepare a charge sheet, they can register the charge sheet and charge Mwendwa with whatever offense that they would like to charge them. So what the court has just said is that for the 7 days, Mwendwa is supposed to be out on bond or on bail as per the earlier conditions, which include not visiting the stadium, which include not interfering with witnesses, not contacting employees of the federation. Those earlier terms have been maintained, but they have been maintained for only 7 days. If within 7 days the state does not take steps to charge Mwendwa, then this case or this file, which is a miscellaneous file, will stand closed, which means that there will be no terms within which Mwendwa would be operating on, in terms of there will be no restriction. He'll be out of the court's jurisdiction, or he will not be in the hands of the court anymore after 7 days. That's basically the interpretation.
A ruling that maybe favors you and Mwendwa on his side. What do you make of it? Is justified?
Sorry, could you repeat the question, please?
Ruling for you and for your team.
Yes.
What do you make of it?
Well, in our view, objectively, of course, the ruling is well reasoned. If you looked at the affidavit in support of the application, and by the way, Section 36A is mandatory in terms of if you bring a person to court by a miscellaneous application wanting to detain them for more than 24 hours, then the law, that is Section 36A, of the Criminal Procedure Code gives you an obligation, requires you to put it in writing through an affidavit to state the reasons. If you looked at the affidavit, which I think you have, those 4 grounds were not really reasons. And I think the court was right in making that determination.
Thank you so much, Mr. Mwendwa.
Even when I began asking about the inspection on 2nd of November on the floor of the Senate, my mind was very clear, like it is clear now, that any attempt to find fault in Mwendwa in the manner they have attempted to do so is unlawful. I am of the same opinion that, and I will say this with my eyes closed, that even if they charge him based on that inspection report, it's wrong, because the Sports Act and its regulations require that FKF should be given an opportunity to comment on that report before they take action. I said this over the weekend and I'll repeat. The only thing that they wanted was to remove Nick Mwendwa out of office. They are now stuck because FIFA has said put back Nick in office. We will discuss it when he's in the office, and that's why they have sought for a meeting. Because you cannot violate the rights of Nick Mwendwa. You cannot violate the constitution so that you satisfy what I call political expediency, and then painting Mwendwa black, you know, give a dog a bad name and then kill it, so that you make Nick Mwendwa look as if ideally is a criminal, he is corrupt, and whatever it is, without a basis. We have evidence, we have tabled information that shows, in fact, it is the Cabinet Secretary of Sports who ought to answer the question as to why our records show that she has given FKF more money than they have received. And we'll continue asking those questions, whether they charge Nick or not, because the law must be followed. The Cabinet Secretary is not above the law. The politics of this country should never, ever get into sports. We can play politics in the diocese, but insofar as sports is concerned, the government of Kenya should stay back. The reason why we are facing all these bans is because the government of Kenya has is interfering with sports. And we did not tell them at any time, do not inspect. We are happy for them to inspect, but inspect, follow the process, charge if you need to charge, but at the same time don't interfere, use blackmail, paint everybody looking bad. And then now the court is right. They say between Friday and Sunday, how is it that the state could not make up its mind whether to charge him or not? And I'm glad that the court finds it's in bad faith, it's malicious, and we were right all along that they violated the process, and we will now wait. But even if, as we wait, it's not going to change our position about this matter. We will still challenge the charge if they bring it.
Okay, looking at it, there's a new thing that they should be handcuffed. Somebody who has authority, who's holding position of power. Those who understand criminal jurisprudence and criminal law and the right of innocence, which is primary. In fact, by the way, the only right that is not encumbered by anything in the Constitution is the right not to detention. That's one, and the other one is a fair trial. There is no exception in the law. So when you bring Nick Mwendwa into court, and when we went to see him with my good friend, he didn't have handcuffs at DCI, at Gigiri. When he comes to court, they must humiliate him by putting him in handcuffs and then showing that he's a criminal. That is why Dr. Aminwa says it imputes in the eyes of the public that he is a criminal. That's really what they want to achieve. And it's something that we must resist, because unless a person resists arrest, you are not supposed to handcuff him. That is the jurisprudence that is followed all over the world. I've not seen it happening here, and it's very wrong. For somebody to just walk here and handcuffs, and when they walk back into the cell, you remove the handcuffs. And it's important, and I would have preferred, in fact, my sort of a finding or a ruling from the courts. And this is a matter that ought to, for criminal justice system, the lawyers ought to continue hammering this point, that we are not going to reform the criminal justice system when you handcuff people who are not supposed to be handcuffed unless they have resisted arrest, and even going into prison. There's a way that we ought to reform the system so that you give prominence to innocence. Give prominence to the right of innocent persons. Thank you.
One more question.
Yes.
And what do you make of the fact that Samina has failed to honor summons?
I'm not surprised that CS Amina has not honored summons. In fact, in my case, she has refused to answer the questions because those questions that I posed to the ministry cannot be answered without the cabinet secretary showing that what she was doing before the inspection was malicious. I pointed just one aspect, that the persons who went to Nick Mwendwa's to FKF were DCI officers and NIS officers. It has been proved. The person who saw the affidavit here is a DCI officer. So I was right that if you are truly doing an inspection, why would you send DCI? You ideally would send an auditor. It is the auditor who will tell you that there's a problem. But then you send a DCI officer to go and do audit, and then you come up and say money has been stolen. That's what I was trying to demonstrate. Thank you.